Good morning, everyone. Welcome to Sunday school this morning. I have to say at the outset, this is a difficult format. My hat's off to Joy. For all those joining us on Zoom, I need to remind you to please mute yourself. But if you want to ask questions towards the end or any point in time, you'll need to unmute yourself for the questions. So I trust everyone can hear me. All right, so what we're going to talk about today is the illegal trial of Jesus. But what is not, this presentation is not actually going to be talking a lot about the trial of Jesus. This is a presentation that was created by my father, John Casey. This is my first time to present it. And good morning. And so we'll be going through what it's supposed to cover. We want to cover some of the sources of Hebrew law and some of the peculiarities of Hebrew law. And then later on, if you can, or later on, if we have time here, we will apply it to the trial of Jesus. But the assumption is made on this presentation that you are familiar with the trial of Jesus. You've read it through the Gospels. And if you haven't been, or you will be reading it shortly, we're assuming you're familiar with it, will be familiar with it. All right, so let's dive right in. And I apologize if I'm a little hoarse or mumble a little bit. Like a lot of people, I worked outside yesterday, and so my sinuses are making me pay for it today. And I hope everybody's doing fine at home. Okay. Let's get into it. So, what we want to talk about is Hebrew criminal law. The sources of Hebrew criminal law include the Pentateuch, which is the first 5 books of the Bible: Genesis, Exodus, Leviticus, Numbers, and Deuteronomy. That's sort of if you want to compare it to our laws, it's kind of the codified law, the Constitution, if you will, and the laws that are given to us. Those books were believed to be given to Moses during the time in the wilderness. Therefore, it's also called the Mosaic Law. Another source of Hebrew law has to do with what's called the Talmud. Those are the ancient traditions and rabbinic interpretations and application of the statutory law, the law of Moses, applied in real-life scenarios. These were oftentimes recorded by scribes and became, if you would, comparable to what we have today is called our case law. And it had an equal weight in many instances as the statutory law. The Talmud consists of approximately 37 books. If translated in English, it'd be over 400 volumes. But it's 37 books, and each book touches on a different aspect of human life. There's such things as there's a book devoted to health, a book devoted to marriage, divorce, inheritance, and in order for our discussion today, there are no less than 3 books that are dedicated to the criminal procedure, legal procedures, and procedures of the Hebrew courts called the Sanhedrin. So what I want to talk about now is, again, going back and talk a little bit about some of the crimes and punishments that are found in both the Pentateuch and the Talmud. First of all, for capital punishment, there were 4 primary methods of carrying out capital punishment. One was beheading. Crimes associated with that were murder, apostasy from Judaism to idolatry. There was the capital punishment for strangulation. There were 6 crimes attributed to strangulation, including adultery, kidnapping, false prophecy, bruising a parent, prophesying in the name of heathen deities, and maladministration. Now, what maladministration, that applied to maladministration, wouldn't that be something today shake up our political system if that were the case? Also, the other capital punishment was burning, and that was reserved for incest. There were 10 different variations of incest. The capital punishment was burning. And then there were 18 crimes where the punishment was stoning. And just a few of those are magic, idolatry, blasphemy. I want to emphasize the blasphemy. We'll come back to that's important, obviously, in our discussions of Jesus' trial. Cursing a parent, violating the Sabbath, and violation of duty owed a parent by a child, filial duty. So these are a few of the crimes for capital offenses, and where death was the result. Also, there is a punishment was for imprisonment, and this is unknown to the Mosaic Code. This was created by the Talmud. There were 5 classes of offenders that were imprisonment was prescribed. And that's homicides, and that's crimes where there's some element of murder that was not present for a capital punishment. There's also instigators of murder, hiring a hitman, for example. And also those crimes where if you were an accessory to the loss of life. And an example of that would be if you were involved, or a person was involved in a group or clubbing someone to death, where the person who gave the final death blow, could not be ascertained, then that would be imprisonment would have been reserved for that. Also, persons, if you've have been committed a crime where you had been flogged twice before and you committed that crime again, then you were subject to imprisonment on the 3rd time. And finally, imprisonment was reserved for habitual offenders, meaning not just the same crime, but if you were just continually creating crimes over and over again, then you were subject to imprisonment. Flogging. That is the only corporal punishment mentioned in the Pentateuch. The number of stripes could not exceed 40. It was imposed in the presence of judges, but it could be imposed by any courts. Slavery. The penalty is a penalty reserved for theft, but only if the thief could not make restitution. I refer you to Exodus 22:1 for reference on that. It was imposed only on men, imposed for 6 years, and nothing could be. You couldn't be subject to any degrading things when you were a slave. If you were Hebrew, that would actually be a violation. You couldn't, if you were a slave owner, you couldn't make your slave commit things that would be against their religion. So that's where it's aspect of that. Can everybody hear me all right? Is this looking good? Hope everybody at home can hear me. Okay. There's a section on this presentation for execution of capital offenses. If time permits, we may go back to that. Worried about running out of time, so we're going to suspend that right now. But I do want to make a specific mention of stoning. That's a little different than what we usually think about. Stoning, the culprit was, when convicted, was taken to a hill or a cliff and thrown off the side and hurled to their death. Only then, if they survived, only then did the witnesses to the crime were they permitted to then cast stones to finally put the person to death. And I apologize for reading this. I'm trying to stay on course. I tend to wander, as Barry, if you're watching, I know you're pretty glad I'm doing that. All right. So there were 3. Let's go to the courts. Under Hebrew law, there were 3 kinds of courts. There was the lower tribunal, or also called the Court of 3. There was the minor Sanhedrin, consisted of 23, and then there's the Great Sanhedrin. And the Great Sanhedrin will be important for discussions of the trial of Jesus. That would be the tribunal in which Jesus was presented. So, start with the Court of 3. It was composed of judges. Interesting enough, the judges were selected by the litigants to the dispute themselves. One by the plaintiff, one by the accusing witness, and one then chosen by the 2 that had been chosen. They had to be qualified. The qualified judges had the same meet the same requirements as the Great Sanhedrin. There was a majority of 2 decided those cases. Those cases decided simple petty criminal cases and simple civil cases. You can think of those as similar to our small claims courts and our district criminal courts at the local level. Then the next level, moving up the level of courts, we had what's called the minor Sanhedrin. Now, any town or city that had at least 120 families could choose to have a court. They were chosen at a large town meeting, and they had to meet the same qualifications as any other judge. They consisted of 23 members, and jurisdiction was all criminal cases that included capital punishment. They had other functions too. The way of course, the organization and the civil organization of the Hebrew people, we had the courts conducted all the business. They were legislative. They did administration. They did the executive. It was all done by these courts. So you can think of the minor Sanhedrin as your town council, your town leaders, and so they were also responsible for taxes, charities, management of schools. They had handled infrastructure for the city, such as roads. There's a large volume of material they had to cover, had to handle. All right, so the next court we want to talk about is called the Great Sanhedrin. Now, this is the Supreme Court, the High Court of Justice in civil and criminal cases. They had legislative and executive duties, such as a national parliament, and they also handled appeals from all the lower courts. The Great Sanhedrin is believed to have been created and given to Moses during the time of the wilderness. And if you reference to the Great Sanhedrin, it is created, you look at Numbers chapter 11, verses 16 to 17. And the Lord said to Moses, assemble 70 respected men who are recognized as leaders of the people. Bring them to me at the tent of my presence and tell them to stand beside you. I will come down and speak with you there, and when I take some of the Spirit I've given you and give it to them, then they can share the responsibility with you for the people, and you will not have to bear it alone. So that's where the number became fixed at 70 plus 1. Have a little technical difficulty online. All right, so the organization of the Great Sanhedrin, it had 3 chambers. It had the chamber of priests. The number of members was 23, and this represented the religious element of the people. You had the chamber of scribes, also 23, representing the literary or legal element of the people. And then you had the chamber of elders, also 23, who represented the common element. Now, before some of my mathematician friends start adding that up, you will see that adds up to 69 members. So how do we get to the 71? Well, we had 2 presiding officers, one of which was the high priest. Presiding is the key. Did not conduct the business, but only presided over the meeting and kept order. All right. The qualifications for the judges. Instantly, what we're explaining while we're doing this, we want to explain, this presentation is actually not about the trial of Jesus, but I want to equip you with the necessary tools to, when you read the scriptures, we know it's illegal. We're told it's illegal. As people of faith, we believe it's illegal. What I want you to do is apply what the background that I'm giving you here, and apply that as you read that, and for yourself. Now we're going to know why it's illegal. So that's the purpose. That's the background I forgot to mention. But anyhow, the qualifications of judges. This applied to all courts: the lower tribunal, the minor Sanhedrin, the major Sanhedrin. They must be a Hebrew, a lineal descendant of Hebrew parents. They must be learned in the law, both written and unwritten. Must have some sort of judicial experience. That applies to obviously the great Sanhedrin and minor Sanhedrin. You had to have experience in a lower court before you could sit on an upper court. You must be, I want you to pay attention to this, must be proficient in scientific knowledge, including such things as astronomy, medicine, physiology, chemistry, anatomy, among others. Must be an accomplished linguist. You must be familiar with the languages of the surrounding countries, because the interpreters were not allowed inside the court. So the judges themselves had to be able to understand the languages that might be being spoken. They must be modest, popular, of good appearance, and free from haughtiness. Must be pious, that is, very religious, strong and courageous. Now, there's also a list of disqualifications for judges. Disqualifications include, a judge could not serve if he did not have a regular trade, occupation, or profession in which he made his livelihood. You had to work in some job before you could become a judge and sit as a judge. In trials involving a death penalty, you could not be inflicted, you could not be you could not be aged, overly aged, and you could not be without a child, or you could not be illegitimate. So those last two, I want you to think about those and how that applies, and why, particularly like this last one in a death case, why would you not want your judges being inflicted? Well, think about the mindset. Or if you think, if your mindset, if you have an illness, particularly if it's one that's going to result in death, you might not be willing to show mercy, and that is a common element in the Hebrew law, is always mercy. Always show mercy to a defendant. If you're not without child, you're not interested in the legacy. If you're putting a person to death, and what's going to be the result of that? That person's not going to be able to father any children. So you're potentially cutting off or limiting a lineage. And so great steps were taken to prevent that from occurring. Some things make sense. You couldn't be a gambler, a dice player, couldn't be a bettor, could not be a slave owner. And then this one, you must not have dealt in fruits of the seventh year. Now, what does that mean? That's from Deuteronomy chapter 15. Is in Hebrew law, all debts were forgiven after the sixth year. So if you collected on a debt in the seventh year, you were collecting beyond what the law allowed. And so that disqualified you then from being a judge. Okay, the quorum of the Great Sanhedrin was, you could have surprisingly a low number of 23 of the 71. Votes needed for acquittal of a case, you just need a majority of one. For conviction, you needed, as long as it was a non-capital offense, you needed a majority of one. On conviction of capital offenses, you had to have a majority of two. Now I want to talk about a few rules of the court and procedure. And I want you to take, this is important as we apply this to the actual trial of Jesus in front of the Sanhedrin. A few notes. A simultaneous and unanimous verdict of guilty, if it was rendered on the same day of trial, it had the effect of acquittal. I'll repeat. If you had a unanimous decision on the first day of trial, it was the same as acquittal. It was found to be lacking in mercy, was thought to be the result of conspiracy rather than a judicial deliberation and pursuant to the procedural rules. It violated the procedural rules. There were no lawyers or prosecutors in the courts of the Great Sanhedrin. There was at least supposed to be one judge who had to be an advocate for the accused. That was the only, other than judging the evidence and the witnesses, that was the only rule for a judge. At least one had to advocate. Not only did they had to advocate, they had to, when I say advocate, they had to make argument on why a person, particularly a capital person, should not be convicted. You had to have the one. The prosecuting of witnesses was actually handled by a witness. You had a prosecuting witness who acted as the prosecutor. Other things, no trials. The trials could, no part of criminal procedure, including trial, could take place before the morning sacrifice. Morning sacrifice could not take place before dawn. Trials had to conclude before the evening sacrifice, before sunset. The trial had to take place in public at the Great Hall, or as the Hall of Hewn Stones. And that was only after a public accusation of the crime was made. That would be akin to what we would call the indictment. You had to have a public statement of what the crime was before the trial could even begin. And also, no trial could start. That if it could not end by trial could not end by the end of one of the holidays. There are 7 major Hebrew holidays. It couldn't take place on one of the holidays, and it certainly couldn't take place on the Sabbath. So if a trial could not start and end by that particular time, then the trial could not take place at that time. It had to be continued to the next available day. At each trial, there had to be 2 or more scribes present. There was one that took down the testimony that was favorable to the accused, one that took down testimony against the accused, and so there had to be some recording. Witnesses were brought in the chamber one at a time, starting with the accusing witness, that would be the prosecuting witness, and finally followed by defense witnesses. There was an examination of the witnesses by all the judges. Notice the witnesses, not the accused. There was not an examination of the accused. Accused in Hebrew, much like our current system, you were not compelled to testify, and if you want to remain silent, you could. A lot of similarities between Hebrew law and our current legal system in regards to the way a criminal defendant is treated and the rights of a criminal defendant. A lot of our legal system, particularly our criminal system, originated from Hebrew. We're thought to have come from England, but it came from the Romans, and the Romans were greatly influenced, particularly in later years, by the Hebrew influence, particularly when it came to criminal defendants. At the close of evidence, there were arguments made both on behalf of the accused, by at least one judge, as always spoke, and then there could be arguments made against the accused. Following arguments, they began balloting. Now, the way balloting was handled, we started with the youngest judge first. Each judge had to stand, make his vote known, and explain his reasons for his vote. Following the tally of the votes, and again, there could not be a unanimous guilty verdict. And again, why? Because at least one judge had to advocate on behalf of the accused. So you couldn't have a unanimous vote. If you did, the effect was acquittal. If the vote was acquittal, majority plus 1 for acquittal, the trial ended. If the vote, in capital cases particularly, if the vote was to convict, that would be majority plus 2. the trial had to be adjourned until the next day. Everybody hear me? You had a capital trial could not take place in one day. The thought was that you had to have some deliberation. You're dealing with someone's life. You want to give another opportunity for the defendant to present some additional testimony. Again, the entire system was set up on preventing the wrongful conviction of an innocent person. The Hebrews believed, and which we believe this today as well, it is better that a guilty person go free than to convict an innocent person and that their blood be on our hands. The belief is that if we miss it, God will take care of it. So everything is geared towards that. So again, we had to have a day in between the first vote and the next vote or the rendering of the verdict. The next day, the second day of the trial, continued, and it repeated. Repeated the process from the day before, in that we would have arguments. Any new witnesses would come forward, and he would have a vote for acquittal and or conviction. If you had voted for acquittal the day before, you could not vote for conviction the second day. You couldn't change your vote. Once you went with acquittal, you couldn't change it. You were fixed. If you had voted for conviction the first day, you were allowed to change your vote. If after the second day of trial, and there are some texts that believe that it was actually had to require 3 days. You had to have a day of waiting in between, so it was actually the third day before verdict and sentencing to take place. That's in dispute, but we know it's definitely 2 days. But if the vote on at least the second day of trial, was to convict, then the sentence was carried out that day before the evening sacrifice and sunset. Okay, witnesses, we're going to go on time. Witnesses and evidence. The qualifications for a witness is almost identical to a judge. Unfortunately, it couldn't be a woman. Had to be over 13 years of age, at least reached age 14, and you had to be Hebrew. The disqualifications were also nearly the same as for judges. Number of witnesses required. There were a minimum of 2 witnesses required for a conviction. If it was a capital case, it required at least 3 witnesses. You have a prosecuting witness, and then you had 2 others. Reference to at least the 2 witnesses are Numbers. We look at Numbers 35, verse 30. Also, the witnesses, as far as their testimony had to agree. They had to be able to recite the entire set of events setting forth the crime. All elements. They had to agree with each detail. A modern example of this would be our crime of burglary. Burglary consists of breaking into a dwelling and then committing a crime such as theft inside that dwelling. And so an example of using that would be if you had one witness who saw the accused enter a dwelling, didn't see him leave, but you had another witness who saw him leave with some object, then that could not support a conviction, because both witnesses would have to see the entire proceeding, see the defendant go into the structure, come out with the item. That would be the 2 witnesses of the complete set of events. Witnesses, there was no oath required. Remember, we're Hebrews, we're operating on Hebrew law, and so the 9th commandment applied: "Thou shalt not bear false witness." Testimony was given separately in the presence of the accused. The accused was never required or compelled to testify, and a confession of the accused could never convict without at least the other 2 witnesses. Here's why. False witnesses receive the punishment that the accused would have received if convicted. So if you're accusing somebody of a crime, seeking to have somebody put to death, the result of that crime, the punishment of that crime is death, and you bear false witness, you yourself will be put to death. So it cut down on some false witnesses, I believe. Okay, so what I want to do is, if you haven't already read the trial of Jesus, if you want to turn now, a good reference to that is Mark 14, 43 through 65. But I'm going to give some highlights of what we can put together through Mark and through Luke and the Gospels. Is what we know. Well, we know Jesus was arrested at night in the Garden of Gethsemane. The day before, it was the day before Hebrew holiday. We know it was at night or early in the morning, I should say. There was a large group of priests, elders, and guards. So in other words, who went to arrest Jesus? Judges. The judges who were being unbiased, who were not to, who were going to be judging him, and they were actually the ones going to arrest him. They would have been disqualified as judges based on that. There's also some troops. And this, I think the troops, there's some speculation of whether or not they were, or not speculation, some statements that they were maybe Roman guards. More likely I think they were probably temple guards. Now they could have been a detachment of Roman guards or Roman soldiers that were assigned to the temple. Because you have to remember the high priest was, at this point in time, had been appointed by Rome, had not been elected, he was appointed by Rome. And so there had been a lot, as we'll talk about it, Annas, he was former high priest, and he had served many years and had been out many years and had successfully put all his sons as the high priest. And then the current high priest at this time was his son-in-law. So there had been certainly, at that particular time, there was some political aspect of being the high priest, and so it's certainly plausible that there would be Roman soldiers acting as guards for the high priest and the judges. All right, the large group of priests, elders, and guards, they came with Judas. And I presume Judas was actually paid. We know Judas took a bribe, and we know he went and identified Jesus. And think about that. If Judas was the only way they could identify Jesus, that means we didn't have a prosecuting witness or other witnesses who could identify who Jesus was. And so I believe he was going to be was hired to be the prosecuting witness in this case. He didn't make it, as we know. We know he was paid a bribe, and then if he had been paid and it came out as paid, he would actually have been disqualified as a witness. All right, where was he taken? Jesus was taken at that point in time to the private home of Annas, the former high priest, for a preliminary investigation. Again, at night, or at least before, in the early morning before the morning sacrifice. Again, no part of the criminal procedure could take place at night. From there, he was taken to the private home of Caiaphas, the high priest, for trial. During the trial, that we know they were looking for witnesses, and they finally identified and finally brought forth two. We're told they gave false testimony. But we know the two witnesses against Jesus were arranged to testify regarding what was he charged with. The witnesses say that he was going to tear down the temple. So what Jesus was being charged with at trial was threatening the temple. In at least one account of the two witnesses, one says that he heard Jesus say, "I'm going to tear down the temple." Another witness says that Jesus said that if the temple was torn down, I will rebuild it in 3 days. So by taking that face value, those accounts do not agree. One says he said he's going to tear down the temple. One says if it is torn down, or when it is torn down, then I will rebuild it. Jesus was questioned by the high priest and took his answers to be a confession of blasphemy. What we also know is there was unanimous verdict without debate. There was no arguments for or against Jesus. The high priest tore his robe and said, "What more do we need?" He declared what the crime was. And again, the crime was blasphemy, not what he was originally brought in for. So it would, even if there had been an indictment, which there wasn't, it was different from what the accusing witnesses or what the witnesses to him were testifying to. They were not testifying necessarily to blasphemy. But that's what the priest said. The high priest said, "You're committing blasphemy by saying you are the Christ." Jesus was then taken to Pilate and charged with sedition. That is what he was. If you read the gospel, it says he was charged with inciting the people not to pay their taxes. Didn't mention anything about blasphemy. Didn't mention anything about the tearing down the temple. It was encouraging people not to pay their taxes. That was sedition. Pilate found no guilt with him, and when they insisted, he sent, because it was sedition and had to do with more of a local element to it, he sent him to the next person who had authority over him. Since Jesus was from Galilee, he sent him to Herod. Now, interesting note that Herod, this is not the same Herod that was in power when Jesus was born and put the babies to death, but this is his son. All Herod was interested in, he had heard about Jesus, and all he was interested in seeing or hearing from him was that some sort of miracle. He said, "I've heard you've heard about all these miracles. I want you to perform one for me." Well, Jesus didn't do it, and so they mocked him. And Herod was the first one that branded Jesus as the king of the Jews. The soldiers put a robe on him and a crown and sent him back to Pilate. When Jesus was sent back to Pilate, the charge became treason. Again, we have a new charge. The first one didn't work, the second one didn't work, the third one didn't work, so we do another one. It's called, and we do a treason. Pilate again could not find any fault with him. He argued with him. Excuse me. Finally, the charge that the priest put on in front of Pilate was, well, he's no friend of Rome, and he is inciting the people to riot against Rome. That was what was the belief. Well, now this got Pilate's attention, and Pilate, he thought this was an innocent man, certainly didn't want any kind of trouble with Rome. And I can only imagine that, again, you have, Annas had been in place far longer than Pilate had. And Pilate didn't want any kind of political trouble, didn't want any trouble with Rome. And so my thoughts are that by stating this, they were going to use their sources to report back to Caesar that Pilate was allowing Jesus, King of the Jews, to incite riot against Rome, and that could have caused a problem for Pilate. And that is finally why Pilate condemned, or Pilate allowed, I should say condemned, he allowed Jesus to die. And important to note that he was incensed by what they were doing. He's the one, Pilate is the one that said, wrote the inscription, "Jesus, the King of the Jews," which just infuriated the priest. And they already wanted him to take it off. He said, "What I have written, I have written." And then, of course, Jesus was crucified. So we have Jesus arrested, tried for multiple different crimes, and put to death in less than 24 hours. All right, so again, we're looking at 40 minutes. I'm going to allow some time for some questions if they come up. So what I would like to do is to state for you my reasons for why I believe and why we're told that the trial of Jesus was illegal. I will leave it to you to go back and read the accounts of the Gospels of the actual trial of Jesus. I would refer you to, for this trial in front of the Sanhedrin, I refer you to Mark 14, 53 through 65. There's also some other accounts, mainly the trial of Jesus in front of Pilate from the other Gospels. So I'm allowed you to go back and read that. We won't cover that here. But what I want to do is give a summary of why I believe and why the Gospels state that the trial of Jesus was illegal. First, Jesus was arrested at night. Again, no proceeding could begin before the morning sacrifice. The arrest was illegal. The indictment was illegal. There should not have been a trial to begin with. The preliminary hearing in the private home at night, that was not allowed under Hebrew jurisprudence. The trial of Jesus in a private home in front of the chief priest, trials could only be held in the great hall. Announcements of convictions could only be announced in the great hall. There was no prosecuting witness. The chief priest acted as the prosecutor. Chief priest, therefore, should have been disqualified. The judges were not allowed to originate charges. And again, remember, there's a difference in what the charges were. Charges start off with threats against the temple. The final charge from the high priest in the Sanhedrin, great Sanhedrin, was blasphemy. There was no defense allowed for Jesus. At least one judge was required to act as a defendant, act on behalf of the defendant, and make arguments on the defendant. We didn't even have arguments, much less having someone support Jesus. It was a unanimous verdict. Under Hebrew law, a unanimous verdict resulted in acquittal. Convicted on the confession of Jesus. There was no guilt under Hebrew law. No guilty verdict could be had on the confession of the accused. It still, even if you had a confession, it still required the two witnesses. Convicted by disqualified judges. Remember, at least some of the judges had paid a bribe to Judas. Some of the judges had accompanied him and the soldiers on the arrest of Jesus. They would have been disqualified. We know they went. We know they were with the council when they deliberated because they took him. We know the judges took him to the two places. So we know their presence. They had an interest in the outcome. They should not have participated, and they were disqualified. And if you're a disqualified judge, you can't vote on the outcome of the proceedings. The trial began on the day before the Passover feast. Capital trials cannot begin unless they could be concluded before a Hebrew holiday. There were 7 major Hebrew holidays, and it had to be concluded before the Sabbath. Capital trials required a minimum of 2 days and 2 votes, two completely different votes following arguments and evidence and arguments. Jesus was not convicted of the charged crime. They didn't match up. Your conviction had to match what the accusing witness, the indictment in today's word would say. It had to match the indictment, what the charge. It changed. It changed multiple times throughout the course of the proceedings. In this less than 24 hours, it changed several times. First of all, Jesus was charged with threatening to destroy the temple. He was found guilty of blasphemy the first time. He was later charged with sedition, found innocent of that. He was then charged with treason, actually found innocent of that, but then he was put to death for organizing a riot against Caesar. Okay, the sentence for blasphemy was not announced in the only place it could be conducted and announced, in the Great Hall. For all those reasons, and as you're reading the account of the trial, I want you think about those, and I want you to apply that, and those would be the reasons that the gospel say it was an illegal trial, not right. Finally, I want to make a note on the charge of blasphemy. That's taken from the Ten Commandments. Thou shalt not take the name of the Lord your God in vain, for the Lord will not hold him guiltless who takes his name in vain. That is the basis for the blasphemy. As we can say, blasphemy as a charge technically does not even apply in this case for Jesus. It was just a trumped up charge because we knew it carried the death, a capital offense, and carried the death penalty. And also finally, I want you to notice that what I've already said about the witnesses, they disagree. So finally, for all those reasons, we find that the trial of Jesus was illegal. So what I want to do is, that concludes the presentation. Again, and what I failed to mention was, notice all the similarities between our legal system, particularly as it applies to criminal defendants, and the Hebrews. So I think it's perfectly okay that if you didn't remember anything that we covered today, that when you're reviewing and reading the trial of Jesus, it's okay to apply what you know about our current criminal system with the trial of Jesus. It's fitting. It applies. It works. Okay, so now if there's any questions, I'll try to figure out how to get these questions. And again, I think be sure you unmute your computer, your microphone, so we can hear it. And if you'll say it, I'll try to repeat it to the microphone for the online presentation there. All right. Are there any questions? Okay. Well, I don't see anything. I want to thank you for your time today, and I'm sorry I kind of rambled on. This is been my first presentation of this. I don't like I said first, or maybe I didn't. This is actually my father's presentation. He researched it using many sources. I don't wish I had a list of all his sources. I know that one of the sources that was used, and it's tough reading, but if you ever want to use read a book by Flavius Joseph, he's a historian, Jewish historian, and it's hard to read, but it gives an account. That's how from him we know who the judges were at the time of Jesus, an independent account of who the judges were. So they confirms what the gospel says. There's many other aspects of Hebrew, the origination of Hebrew law in Flavius Joseph's accounts. There's many other sources. There's several books on the trial of Jesus, and I know and I want to thank Linda Ayers for making me do this. I talked to her about it. She asked me one time about Dad's presentation, and I told her, yeah, I'd like to do it. Well, thank you, Linda, for forcing me to do this. What I'd like to do at some point in time is I'd like to convert this to I want to write a brief, an appellate brief for Jesus, as if he were convicted. I think I'd like to do that. I think it would be a lot of fun to do that. And also, at some point in time, if somebody wants to help with this, I'd like to put together a little play involving kind of the modern, what would Jesus' trial look like in our modern system. I think that could be a lot of fun. So, again, no other questions. I guess we'll conclude that. Thank you very much.